The story of the hairy hand starts in 1915 in the industrial town of Berlin, New Hampshire, USA. One of the town's young residents was 11 years old, George Hawkins, a student at Berlin High, where he played goalkeeper in the school's soccer team and captained the baseball squad.
George's injuries were serious. He was unable to open his fingers and the pain was considerable. As a result, he had to give up sport, something he loved, and he was unable to hold a pen properly. Naturally, he wondered if he would find a job with the local paper mill, something he had planned to do after leaving.
Okay, George, let me see your hand. I can make it better by doing a skin graft.
A skin graft? Are you sure it will work?
Absolutely sure. I've done it 100 times.
Fantastic, but how much will it cost?
I will do it for $100.
Okay, good. Go ahead, doctor.
Dr. McGee botched the operation, making a number of drastic mistakes. First, he did not remove the scar tissue before trying the graft. Second, he took skin from the boy's chest instead of his thigh. The thigh was the common procedure.
The reason for the doctor's failure soon became evident. His claim to have completed hundreds of skin grafts was a lie. He had watched a couple of operations on the First World War battlefield, but that was all.
Dr. McGee not only failed to improve George's hand, but he actually made it worse. George was still unable to open his fingers. He experienced an increase in the level of pain, but worst of all, his palm now covered in thick hair, giving him a scary appearance.
The defendant's case is based on two issues. 1. That no contract was ever entered into. 2. That if a contract was entered into, Then the damages decided by the trial court were accepted. On the first matter, the New Hampshire Supreme Court finds for the appellant. The parties entered into a legally binding contract, and one of the terms was the defendant's promise: "I will guarantee to make the hand 100% perfect." The defendant did not do this, and he was clearly in breach of his condition. Now let's turn to the matter of damages. In the trial, the judge said the following to the jury: "If you find the plaintiff entitled to anything, he is entitled to recover damages, first for the pain and suffering due to the operation, and second for the injury he has sustained over and above what the injury had before. Authority for any specific rule of damages in cases of this kind seems to be lacking, but it appears that the foregoing instruction to the jury was erroneous. The purpose of the law of contract is to put the plaintiff in as good a position as he would have been if a defendant had kept his contract. We therefore conclude that the true measure of the plaintiff's damages is the difference between a perfect hand and the value of the hand in its present condition. We therefore order that a new trial be heard in which the jury can be correctly instructed."
Mr. Hart, what damages do you think the doctor should pay? What did the doctor promise?
There was a promise to fix the hand back to the way it was before it was burned.
And the result of the operation?
The hand was much worse than before he went to the doctor.
How should the court measure the damages? What should the doctor pay the boy?
The doctor should pay for what he did. He should pay for the difference between what the boy had, a burned hand, and what the doctor gave him, a burned and hairy hand. He should pay for the difference between what the boy had, a burned hand, and what the doctor gave him, a burned and hairy hand.
The purpose of the law of contract is to put the plaintiff in as good a position as he would have been if a defendant had kept his contract. We therefore conclude that the true measure of the plaintiff's damages is the difference between a perfect hand and the value of the hand in its present condition.
This is the 100% perfect hand promised by Dr. McGee. This is the deformed and hairy hand the doctor gave him. The difference, $47,000.